Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Today I'm going to cover the questions on the channel in the comments. Anyone coming live can ask their questions as well. Okay, so first, the important update from tonight, I think 12 a.m. tonight, the immigration health surcharge will increase to whatever the new changes are that I've stated in the other videos. So yeah, any applications thereafter would be charged the new immigration health surcharge. For adults, it is increasing from 624 per year to 1035 per year of visa. For children, students, student dependents, and youth mobility visa holders, applicants for those category, it's increasing from 470 to 776 per year of visa. Okay, so that was the update. I'll take the questions on the channel. So first question from Fatima, we want to responsible must mention job. It's most pay slips. Yeah, the question is about a financial requirement for spouse visa. Your husband has changed jobs within the last 6 months, so he has two jobs in the last 6 months. Your question is if he shows 6 months pay slips for the two jobs, is that okay? Usually, whenever there are when the sponsor who is meeting the financial requirement, if that individual is not in the job for the last 6 months, then there is a different formula. Category B is used where you have to prove last 12 months of income. So you can use 6 months of income and then add zeros for the previous 6 months, zero income for the 6 months. So it's quite a complicated formula. It is difficult for me to explain, but yes, if his salary is over 18,600, if it meets that formula, you may be able to use his last 6 months of pay slips. But there are two points to be met in that category B. Current salary should be more than 18,600. That is, the letter from the employer should state that. And whatever salaries he has earned in the last 12 months, earned gross income should be at least 18,600. That's how you prove category B. So next question, what if you want to do work from home, like you want more of a self-employed, will you continue working your contracted hours? So this question is on my video for setting up your own business or registering a company on a skilled worker visa. So the question is, can you do a job like A1? You can do any self-employed work. Preferably, you should avoid doing all of these self-employed works. If Home Office finds it out at the time of ILR and they question you on these factors, saying there are different sources of income, whatever that is, A1 or any self-employment, the only question that will have to be answered, that would be raised, is, for example, if you were contracted for 40 hours of work for a skilled worker visa, how much time were you really giving for that A1? Were you really working 40 hours in your main job? Those are the questions that you may have to justify. So, depending on the income, how much time you are allocating, self-employed businesses, anyways, skilled workers cannot be self-employed, so that is some confusion going on that I've heard. But I would say avoid those A1 jobs and also if you are just the one who is picked up and you are investigated, Home Office will give you a very hard time at the time of ILR. Okay, Mohammed, live question. Could you please talk about wrong cost issuance and also the current cost delays? Also, any insights in the government changes and their policies to deal with the application backlog? So I'll try to address. So this is in 1 minute, whatever I can. Wrong cost issuance. So if your employer has issued, I think you asked previously also, so I know the context. So your employer issued a undefined cause inside instead of a defined cause, and then you filed application. I think it is on hold or something like that. Those were the facts that I remember. So yes, if the Home Office, when they process the application, they will check if the correct cause has been issued. So if a defined cause is required and an undefined has been used, they will definitely hold it and they will ask for the applicant to provide the correct type of cost. I know that there are cost delays. I know in your case also your employer has applied, I think so. So there is not much that you can do, as I already said. Home Office has to, the employer has to follow up through the lawyers or however they want to, through the business help desk, and see what can be done. the only way to solve that problem, because it's the employer's mistake, home office, it's not home office's mistake. If an wrong cause has been given, they may also come and investigate the employer as to they don't even understand what is the right type of cost to be given. It's quite a big mistake. It's a compliance error. If such a mistake is found at the time of an audit, which happens whenever it happens, they would straight away downgrade the license to B rating. So it's quite a strict action that is taken. No doubt, in the initially they may not take those many actions, but they are not happy with employers who don't understand the system and try to issue incorrect causes or whatever that is. That increases their work, and yeah, that's common practice from them. So yeah, the employer has to follow up with them, try to get the correct cause. That is only my suggestion. Get the corrected cause, define cause, and give it to the case working. And any insight on the government changes and their policies. Yeah, I cannot go into the details of policies on this live. I am making several videos on whatever changes are happening slowly. But then, yeah, changes will come into play. Today, the immigration health surcharge will increase from tomorrow, I think tonight, 12 a.m. onwards. So that is the change that is happening now. Other changes, rules have not been published yet. We only have the fact sheet and all from the Home Office. So on that, whatever interpretation we can do, we are doing that. I may make other videos. Previously, I think last week I've made on the care worker visa changes of dependents, etc. So those are the changes coming in. Nothing has been published yet except the news part. Okay. Next question on the channel. Visa. I'm on PSW after completing my master's at the moment. I'm planning to start PhD too. Question is, can I get another PSW after completing PhD? Yeah, the question is about getting two PSW visas, graduate routes. Graduate route an individual can get only once in his lifetime. So that's I know it is stated in the immigration rules. I'm sure about that. So you completed your masters, then you want to go on PSW, and then again want to do PhD, and then go on to PSW. You will not get the next PSW. PSW is only once in a lifetime. That is stated in the immigration rules. Latest update: UK visa is open for Indian nationals. Yeah, for Indian nationals, I'm not sure exactly when they are opening, but sometime around February they may come up with some news. With the youth mobility visa, the ballot opening, I know there are several questions that have been asked for Indian nationals. The number is very less. It may just, yeah, so, but whenever it opens, they will publish the news and you will have the timeline to apply for it. So no need to worry. It is not that they have that window open. Throughout that window, whoever applies, and then through the ballot, if you're lucky, you do get it. So there is nothing to worry. Just keep updated on Home Office news or check on that youth mobility visa page. We don't follow it that much. Only the updates come in because the number of visas are very less. It's not that much even talked about. So yeah, just follow up on the youth mobility page. That should be enough for you. Henry, why are cost approvals getting so long? Yeah, cost approvals are getting so long because Home Office has been unreasonably asking a lot of information. I just downloaded. I'm going to make another video on that one. Where is that? So Home Office is asking employers really unreasonable things. I have a questionnaire that has been sent to one of the clients, especially care homes and all. If you are trying to depend on the courses for care homes, they are asking so many questions. And also, once those questions are sent, it's quite in a messy situation right now. Many times, decauses are refused even after sending the information. Sometimes, I remember another immigration lawyer, he told me that just because the hours were different, there is some big care home and they are representing them 40 hours, 42 hours. Others are working 42, someone else is working 44. And this one that they applied was 40 hours. So Home Office didn't like that and they refused it. Very unreasonable refusals are coming through. Let's see what happens. So these are the questions that come usually. They need an explanation as to why your business needs to recruit additional sponsored workers. Explanation must be specific to a business. This is a standard questionnaire that is sent to all the care homes. Anyone who is applying for DCOS for care homes, definitely, I'm sure they will also go to other areas, building areas, builders, and chefs and all of that. But care homes, every care home is receiving this, and It is like a remote audit. That's what we call it. A full job description include main duties. That's common. Official contracts, agreements to demonstrate you have genuine vacancy. So they are trying to test the genuine vacancy aspect very, very, very strictly. I've never seen this before in my career. So hierarchy chart of who's dealing with the organization, vacant positions, a staff rota. This is very, very new. I see a staff rota dating back 4 weeks from the date of this request. So they want to see if the request was made on 1st of November, they want the whole of October's rota. They just don't believe any care home. That's what it looks like. A staff rota dating back 4 weeks from the date of this request to demonstrate what duties your current employees are undertaking and where they are working. Many, many lines. I'm just reading you some of the main lines that I see. It's a long two-page questionnaire and which needs a lot of information. And copies of employment contracts between your business, so care homes business, and existing workers. You sponsor for each SOC code. You are sponsoring migrants. We will only accept draft employment contracts. If your business has not previously recruited, okay, a fully completed additional information pro forma, and there is a long, what else is there? It's really very long. Even a lawyer will take a week to build up all these things. I don't know how employers are going to deal with this. So this will incur blah blah blah. Okay, they are putting the paragraph, and there is another pro forma also. Trying to open this one. So a lot of unreasonable requests coming from home office. I know they do, and there was some frauds and everything was going on, but then now they are just asking these questions to everyone, whoever is applying, even for 1D course or 10D courses, any care home that is applying, whether the biggest of the care homes or the smallest of the care homes, everyone is getting this questionnaire. Care Quality Commission registration. Please state the date registration. They want to see how long you are registered. Date, registration number of the care provider. Okay. Uh, Teacher status. Okay, overseas trained nurses. Okay, how many? NMC pre-registration. It's quite a special questionnaire. I'm looking at this. This is only for care homes. I think they have made this on purpose to ask all these details for care homes. It is asking specific questions for care home related jobs. NMC pre-registration number of nurses, NMC full registration, registration number, date of registration, qualified, unqualified, who are, yeah, teacher status, who has the teacher status of nursing, quite a long one. Tradable points, okay, that is fine. This includes allowances. Allowances somewhere I think employers were hiding. They have marked it in red. I've never seen questionnaire marked in red, but a paragraph is marked in red by a home office caseworker who has sent this questionnaire. This includes allowances that you are paying to the person. This includes all payments for visa costs. They are very much killing on the abuse of the visa system. They are asking any allowances. This includes that you are trying to include in the salary and you are telling us this particular salary, and if any allowances you are also using in the salary amount, this includes all payments for visa costs. They know that employers have been trying to recoup all these costs. They want specific things to see if the visa has been sold, if the DCOS has been sold. They are investigating left, right, center. That's what I would put it. This include all payments for visa costs, everything, immigration and surcharge, IHS, ISC, DBS checks. DBS checks also, I think employers charge for that. Accommodation, if you're charging anything for accommodation. Specific questions, are they included in the above salary? So whatever salary you are saying, 26,200, 30,000, whatever that is, are these amounts included in the above salary? Are they expected to be repaid? Very, very important. They want a detail of how much visa costs you are incurring. Are they a part of any of the allowances? Are these allowances, are these all these visa costs, DBS check costs, etc., etc., being expected to be repaid by the employee? Very important. Never seen this direction of questioning. Line of questioning has completely changed. If so, has the migrant agreed to this and how much will be paid? So that's the reason they are asking for the contract. And do you have a side letter or something? I don't know what employers do, but if you are trying to have side letters and all where all these arrangements are, home office wants to see in black and white what is happening between the employer and employee, what cost will be recovered, what is the financial arrangement. If so, has the migrant agreed to this repayment? How much will be repaid weekly? They are specifically asking, let's say IHS is whatever 4,000, Out of that, per week, how much are you going to deduct from this person's salary? Is this repayment included in the salary? Hmm. Working hours, you must include paid breaks. Please do not include unpaid breaks. Okay. And yeah, it's a long one. I'm just trying to cover as much as I'll try to make a video and maybe share screen and discuss about it. But this is what is the current situation. As someone asked, Henry asked, why costs approvals are delayed. This is the main reason. Employers are getting such long questionnaires. These questionnaires take time for employers to send. Once they are sent, they go in, sit in the queue for 2 months or so. After that, they are picked up. So that is standard practice. I'm not sure what is that the intention is, but this is what is happening at the back end. Please tell me when dependent going to ban. So the dependents of care worker holders only will be will not be allowed after the changes come into play sometime around April. I haven't got the rules in front of me. They have not yet been released by Home Office. They are still in the drafting zone. So sometime around after 20th March, they say autumn, I think. So 20th March is when it starts. So some date after 20th March, the rules may change for dependents not allowed on the care worker visa. There is no specific date as of yet. Okay, no priority service overstays. Okay, here's and my biometrics. So another question on the channel. No live question. Okay. Applying priority service overstayed in UK. How much time you think for my result? Please reply. Okay, so this was clarified in I had made one of the videos about 3 4 months back where Home Office has confirmed that there will be no priority services. I know in the past even we have done priority services for overstayers and have got parent visas and all of that. But Home Office has changed the model of processing. Priority services will not be offered some to an overstayer who is making the application. So I think you have done your biometrics applied in priority service. There may be some system glitch and all where the payment may have been accepted. But if you have overstayed and then applied, Home Office may not consider it under the priority service deadlines. They may just refund you that priority fees, but you may go under the normal priority, normal processing. Yeah, there were mistakes. I know the system didn't was not changed, and there were people who paid for the priority, but then subsequently the Home Office changed their policy of not accepting priority services from overstayers, especially for these family route visas. So I don't think they will be processing in priority. You may get a refund of the priority service fees, but if you are an overstayer, you are applying on any of the family routes, current processing times may be about 8 to 10 months. That's what I'm aware of. 8 to 10 months parent visa or whatever exception you are asking for, being an overseer you are trying to apply. Philip, what are the main factors to qualify for parent visa under the 5 year route? Main factors to qualify, you should have a genuine and subsistence relationship with someone who is a British citizen or settled in the UK. The child should be under 18 years of age. So this on top of my head, we have a list of documents on our website. You can just go and check there also. The website link should be in the YouTube information. And or a child who has lived 7 years in the UK. So you should have a genuine and subsisting relationship with the child. That's the main factor that you're looking at. And you should take part in the child's life, maybe drop him to school, pick up, do dentist appointments, take them to GP, or if the child is too young, maybe drop them to the nursery, pick up, get you will need letters from at least one of these healthcare providers. It may be a nursery, it may be a GP, dentist, school. That is very, very required. Every time I have filed, I remember I was able to sort out with at least one letter, but sometimes the client was unable to get it, but the caseworker did. They did always ask for this. So you will need a third party confirmation, at least one letter from one of these third parties. Usual third parties are if the child is too young, nursery, if they are in school, then school, dentists, dentists and GPs may or may not give letters. That's a challenging one, but usually schools and nurseries do give letters. That's what will be required, stating that Mr. Philip has been dropping and picking up this particular child from our nursery. They are listed as emergency contact, whatever that is, that helps. A letter from the other parent giving all the information. That affidavit from the other parent is on our website. go through the list of documents for parent visa, you can download it. So parent visa will only, yeah. So yeah, it has everything on that list of documents. That is the main requirement. Sultan, next question. If they already here, can bring dependent after new rules? Yes, the answer is yes. I have read the fact sheet very carefully. If the skilled worker, care worker is already in the UK and the dependent wife, husband, children have not joined, they can join later on. So that is perfectly fine, even if the rules change. So yes to your answer, Danish. And my biometric. Okay. I was overstaying the 10 years after I was applied for. Okay, so the next question, I think I was an overstayer for 10 years. After I returned on voluntary return, now I applied for spouse visa. When I use priority service, I did my biometrics when I accept my result. Yeah, so the this individual had overstayed in the UK for 10 years, voluntarily returned. I'm pretty sure you should have at least completed 12 months after the return, so then you may be eligible. And you applied for the spouse visa, the priority. Spouse visa priority processing is for normal and standard applications. Standard processing is 30 working days from the date of your biometric enrollment outside UK. So 30 working days. But then whether the Home Office may or may not be able to decide on your case within 30 working days. I have done priority applications for overstayers in the past. I've got it in 30 working days, but I'm not sure how good your application has been prepared and filed, what explanations are given for that overstay and all of that, relationship genuineness and everything. So they may decide within 30 working days, or they may write back to you saying that we need more time to consider. It is normal. Home Office suggests if you have overstayed or anything like that, don't file priority. That's what Home Office suggestion is. But they may try and process it within the 30 working days since you paid for the priority service. Thanks for this. My focus is on why will the caseworker grant 10-year route instead of 5 years. So the 10-year route, I will rather put it in the other way around. If the 5-year route parent visa is only granted if these are the two main considerations I've seen. I've fought on many of them where they've granted 10 and I was trying to push for 5. But finally, this is what my interpretation of the whole scenario is. Both the parents should not be together. They should not be in a relationship. If they are together, they will never give under the 5-year route. Number one, that's what I've seen. I've tried and fought on that one, but every time I've got a long letter and explanation with whatever reasons. So I understand the summary. If both the parents are together, are in a relationship, whether married, not living together or not, if you are together, you will not get under the 5-year route. That is very, very important. And I've not got it. I've tried to fight on it. And I've got it for people who, for example, they were husband, wife, they have divorced, they were on a spouse visa. Then the applicant wanted to move on to the parent route to live in the UK. So they have a child together and they are separated. And from the spouse visa, the person switched to the parent visa. So in those cases, usually I've got a 5-year route. That's when you get the 5-year route to settlement. And next is the question. Yeah, it is discretionary. It is on human rights. I wouldn't put it discretionary. It depends on the facts of the case. Speak to an immigration lawyer for the parent visa 5-year, 10-year route. They have to apply the rules properly and yeah, take your advice accordingly. So, Mohammed Hussein, what is the next one? Please talk about new entrant category question on cost. Does the employee have time take up CPD modules with the regulated councils of their professions after arriving on the 5-year visa? So 5-year visa. So if you are you come on to the UK on a skilled worker visa, which is granted for 5 years, you are allowed part-time study. I'm pretty sure it doesn't stop you from studying. So I don't think studying, provided you are working, let's say you are contracted for 40 hours and you are doing that, any part-time study and all of that would be allowed. I don't see any restriction on that. I know people who are on skilled worker visas and they are doing whatever part-time correspondence, weekend courses and all. I don't think that is an issue, provided you are working for your employer for the contracted hours, whatever those CPD modules, regulations, whatever you want to give for your own profession. It may be for accounting, law, whatever that is. you should be fine, provided you are working the contracted hours with your employer. So, Mohammed, thank you for that heart, whatever that is thing is called, a balloon and heart, okay. And is there possible period my course might ready was submitted on 22nd December? Possible period. Sorry, please clarify your question. I don't understand. If you're trying to say how long the course is valid, it's valid for 3 months from the date of assigning it to you. Okay, next question. If a person failed in decision, can he submit his receipt during FLR period? Yeah, so can he submit his receipt? That is for the university to answer. Home office doesn't care when the university takes receipts from you. They can take it remotely, or whether you are legal or not, whether you are in the FLR period. That is for the university to decide. It's nothing to do with the immigration rules. So check with your university if you can submit your receipt while you are in the FLR period, for the leave to remain period. Okay, no more questions. How to contact doctor? Sorry, I'm not sure if this is the right forum. Yeah. So you asked your question on UK visitor visa for private medical treatment. So if you want to take private medical treatment, you have to contact the private hospitals in the UK. I think NHS also does it, but yeah, Google search for it. I'm not the right person to advise on this, but yeah, that's how you can find medical services in the UK. Next question is Rajita. For the new entrant visa, is it mentioned that anyone or more of the following criteria fulfill can a candidate about 26 years fit in this visa category? Okay, so the Rajita has given copied the immigration rules over here. So for the new entrant visa, there are different options. One of them is age under 26 years and several others. So yes, any of those options, any of or more of the following. So even if one satisfies, you can apply for the new entrant visa. That's what you call new entrant salary. That's what I would call. Okay. Yes, you can. If you So Rajita, the answer is yes. One of the categories needs to be met. Okay. Reuse my English test. I've got B1 answer. Okay, so the next question is from Sunil on whether he should give the English test again. So if you have applied for a partner visa, the question is on the partner visa question, and you use the certificate is expired now, it's only valid for 2 years. Uh, can you reuse it again? Yes. So yes, if you used it for a successful application in the first instance, it can be reused. That is my answer. And the level of English B2, that should be fine for an extension. So the level of English required for the first entry clearance spouse visa, partner visa is A1 for the first application, A2 for the second, B1 for the ILR. So you have passed B2, that should be fine, provided you have given the proper right, correct UKVI tests and all of that. So just check that. Thank you, Mohammed Hussein. Thank you for all your appreciative contributions that you have made. Okay, next question. What is private life route for all, including Austrians? Can I do security job on ARC card? So this question is, I think, ARC asylum registration card. You will have right to work in the UK. Let me check. I'm not sure. Right to work. I'm trying to check the question, the answer for this question. I'll state the question and answer that as well. 1 minute. So, okay, with the ARC card, as asylum registration card that is given anytime you register for asylum and your application is under processing. If you're given that card, your question is, can you do security job? So this is what it says. It allows you to work, the ARC allows you to work in a shortage occupation. Difference between permissions, okay, work as a student. Uh, you may not be able to work on the security job. I don't think that is on the shortage occupation list. So you will have to look for a job on the shortage occupation. It can be a healthcare assistant or something like that. Just Google search for shortage occupation list UKVI and that list should come up. So you can work only on those jobs with an ARC. So next question, and research pass is yet to be approved or assigned, which was put in by the employer for the approval in December, still yet to be approved by the Home Office. Yeah, that should be a defined certificate of sponsorship. You are outside the UK, I'm assuming, and the employer has applied on 22nd December. What is the job code? What is the job that you'll be doing? If is it a care worker or something, they are delayed a lot. You can go back when I save this recording. I have discussed about these issues with the care worker DCOS requests just in the initial part of this discussion. Once it loads and saves in next 1 hour, you can watch that. There is a specific list of questions that most of the employers are asked, and Home Office is giving every employer a very hard time with DCOS approvals. I have discussed all of that in the initial part of this video. Next question is, what is the minimum level of qualification required to get UK healthcare visa? Is higher secondary education acceptable? Should the candidate have a degree when applying? Yeah, so the question is about healthcare visa. What is the minimum qualification required? I don't think there is any minimum qualification for the care visa. To the best of my knowledge, there is nothing that I have seen in the rules. Secondary education +2, which means 12th standard in India, that's what they call. That should be fine. I don't think if you have a degree, that's fine, but there is no minimum qualification for the care visa. Okay, next question. Samir Irfan, I'm in the UK sponsored visa, but my company revoked after 2 months. I wanted to go back home. Yeah, so you were on a sponsored skilled worker visa, your company revoked, or maybe company lost your license or they revoked your skilled worker visa. Whatever happened, I want to go back. Yeah, you can go back to your home country. There is no problem with that. If you have any question, you can ask. You can go back. That's my answer. Henry. Okay. Samina, will you please tell how much cost fee are charging for issuing it? Cost fee from the Home Office is £239. That is the cost fee that the employer is supposed to pay. But most of the employments will be subject to immigration skills charge. So immigration skills charge for a small employer is 364 per year of visa. So that is something is added to the cost fees when they are applying, when they are making the payment. Or for a large employer, it's 1000 per year of visa. So 364 per year of visa or 1000 per year of visa, one of them, depending on large or small employer, plus 239 is the cost fees to the best of my recollection. So next question is my little Virat. Any idea when the IHS fee is going to increase? To the best of my knowledge, it's going to increase tonight at 11:59. I think after 12 o'clock, anyone submits an application, it should switch to the new fees. That's what the information I have. That's what has happened in the past whenever they declare a date. So 6th of February. Yeah, so 6th of February is, yeah, tonight after 12. applications should switch and charge the new fees. That's what I understand from how home office works from past experience. Uh, is there will be a problem in future if I come back? So Samir Irfan, yeah, if your skilled worker visa is revoked or the sponsor license is revoked of your employer, you can leave the UK. You will not have any issues coming back unless there was any wrongdoing while in the previous employment or work. If you bought the visa, something was they have something against you as well or anything, those things may be used against you in a future application. If that is not the case, everything was clean, then you don't need to worry about any problems in the future. Next, Mohammed Hussain, are all other healthcare jobs like pharmacists, dentists also highly scrutinized like care work jobs, healthcare jobs? I don't think so. So other healthcare jobs are not scrutinized. Their focus is mainly on care worker. Those are the two job codes. I don't have them in front of me. Senior care worker and care worker. I think if you Google search, you will get the job code. Those are the only two job codes that they are very focused on. Other job codes, pharmacist and all, I think they are okay. They are still in the normal lines. So, Franco, if we change a skilled worker visa company sponsor to a dependent skilled worker, okay, you become a dependent by own. Then IHS paid by the employer for you can that be claimed and used by the employee. So the way the IHS works doesn't matter whatever switching you're doing from skilled worker to dependent or other way around, whatever you're doing. IHS, every time you make an application, let's say you file a new application now, whatever you're doing, switching to whatever, you have to make a new IHS payment. For example, today IHS is 624 per year of visa. Tomorrow morning, when you get up, you try to submit it in the morning, 9 o'clock, let's say, the IHS will be 1035 per year of visa. So you will have to pay 1035 per year of visa, whatever is the calculation for you. And the previous IHS paid will be refunded to the same card. By default, usually it goes to the same card. So if your employer has used it, make sure you follow up with the IHS team, update your card details and all of those stuff. So that is exercise you may have to do with the IHS team to get the refund. By default, it goes to the same card. That is my understanding of IHS. So yeah, the previous IHS goes back. There is no adjustment per se done. You pay the new IHS, get the visa, and the previous proportionately whatever part is not used, whatever visa part is not used, that is given back to you. That's how the refund works. Okay, Nihar, thank you. Sir, Mohammed sir, what time you often come live? Yeah, there is no fixed time. Yeah, I try to do it in the evenings, maybe after 4 o'clock or so. Since today also I had a lot of work, but then I'm sitting till 7. I don't work till 7. I usually end by 6 o'clock. But just I wanted to help on. There were many questions on the channel, so I'm just going live and trying to answer things. Okay, questions coming through. Where are you talking from at this time? In London. Okay, I didn't get your next question. So I'm sitting in London. Next question. I was overstayed in Cyprus, so can I apply for UK visa for skilled visa? So someone who has overstayed in some other part of Europe, Cyprus in your case, you may have to declare that on your application definitely, and then they will test the genuineness of the skilled worker visa you are trying to apply. But you can apply. There is nothing stopping you from applying a skilled worker visa. Just an overstay by itself, whatever explanation you have, you can put it in your application why you overstayed in Cyprus. But immigration also allow you to apply, but the genuineness may be tested by asking you questions as to see how did you get that visa and sponsorship and all of that. Can a person travel from the UK and return back 2 or 3 days before their BRP expires? Any issues? Okay, as long as yeah, you can return back. So the question is about BRP is going to expire in 2 3 days of returning to the UK. That should be fine. Immigration officers do allow. I've never had any issues. Anyone not allowed. I speak to immigration officers also when there are issues and we want to discuss about any cases if they are not happy with allowing someone in the UK. So they are fine to allow you if you just have 2 3 days left on your BRP card and today you come and let's say today is 5th and your BRP expires on 7th or 6th also tomorrow. It is fine. They understand you may be filing for an extension and all. If you have already prepared an application or something, you're already in the process of extending and all, Keep copies of that, any proof you can have, draft application, documents, etc., to show them if they don't believe you for whatever reason. But usually they do allow you, even if your BRP is just going to expire in 1 or 2 days from landing in the UK. Alan, do you think one day the UK government will again, after seeing what effect it brings? Yeah, I think all these changes, these changes mainly, I don't talk about politics and other things, but overall, there is election going to come. It is due maybe this year or just beginning of next year. Election is going to happen. The current government, conservatives, they have to show that they are strict on the migrants. They cannot, technically speaking, these are the we understand when we as immigration lawyers we look at the rules. These are mainly, it's more a political situation also, that they want their votes, they want to be back in power, they have to show what they are doing against migrants. Hence the changes to those senior care worker dependents, skilled workers, we will not allow them unless they earn 38,700. Whatever all these changes that you are seeing in the news, they always come in the news first. Rather they can just put it in the but that's what they want. They want to just get votes against it. That's what I would put it. So there are different agendas in different countries. In the UK, I see that yes, over a period of time, once these changes are brought in, once they start having challenges, whether have not having care workers or care workers not deciding to come to the UK, whatever problems come in, skilled workers not upcoming to the UK, they will slowly change it in future. But for now, at least they are making these changes with the intention of getting the votes of the British public. It looks like so at least for this year, the sailing will be tough. All these changes will come into play, and maybe next year or the year after, slowly, slowly, as soon as the data comes up, things may come in favor again. I don't know how it is, but then yeah, that is what it looks like. But most of these things cannot be sustained in the long run. It just many things are very unreasonable. Yeah, but I cannot change the rules. Yeah, I can just give my opinion on it. So yes, it may change in future. That's my opinion, Alan. But it's just I'm just an individual. It's my opinion. But all other lawyers also agree on this. But then yes, right this year all these difficult changes are coming into play. Even the spouse visa, 38,700 staircasing in a year's time by April 2025. It is a difficult ask, 38,700 for sponsoring someone on a spouse or partner visa and all of that. So all these changes will be challenged subsequently in courts and all. But for now, when the changes come, yes, whoever is filing now will be subject to those and they will have the problems. Kind lawyers file a case against some office for delayed because and they are irrelevant questionnaire. Yeah, we are trying to raise it as much as possible. Uh, it has been raised. Yeah, we are also discussing. We have a forum. That's where I was discussing in the initial part of this video, where other lawyers have also shared their experience and how care homes and all are unreasonably treated. Biggest of the care homes, smallest of the care homes. A long questionnaire is coming. I've discussed the questionnaire also in the initial part of this video. You can watch this video once it is saved. So we are trying to fight as much as possible. We are trying to raise through our Immigration Lawyers Association. Let's see when it comes, when the change happens. But yeah, we can just try from our side. The cases on all will come slowly, subsequently, not at this stage, but slowly, slowly, yeah, they will come on the human rights side. I'm not sure whether cases will come in with the care worker aspect of things, but yeah, human rights side, the spouse visa, financial requirement, and all those things slowly, slowly. Next year, the cases will start coming. May not be this year once the changes come into play. Yeah, at this point, we can just try to erase it to home office and see what is possible, but not much. So, Mina, what band anyone can need to get in UKVI if you want to apply for healthcare visa? What band? So, if you're talking of the IELTS band, so I think it's a pass and fail. The UKVI IELTS you have to give. You cannot use the academic test or the general test. There is a UKVI IELTS. It says the name UKVI in it. It's just a pass or fail. The level of that exam, in my opinion, is about it's about B1 or so. It's about just about B1 level compared to other tests. That's what I can say from my experience. But it doesn't say the levels on that. It's a pass or fail on that test. So next question on the channel. Thanks. Ellen, Samina, lawyers, I think. Okay, all the questions. 7 weeks gone since applied for DCOS, no response. Yes, everyone is talking about DCOS. I discussed at length in the beginning. There are unreasonable requests coming from home office to the sponsors, asking so many things, contracts, working hours, last 4 weeks data of rota, how employees are working, what are their cycles of work, how much are you going to recover from the employee from this visa cost, all of that. It's a big long questionnaire that I have also seen for the first time. I got it today only. So from other employees that we represent, we are getting. It's unreasonable, but we are trying to answer, do our best. All employers are getting that. Home Office is trying to investigate. There are decauses pending for more than 2 months, even 4 and 6 months. I am aware of, but there is not much that can be done. It's a long queue of applications. That is the one side why it is delayed. And secondly, they are investigating each and every DCOS request, especially from any care home required thing. So JJ, 7 weeks gone since applied. 7 weeks is, yeah, it's even more than 7 weeks. There is not much that can be done. Employers can try to follow up through the business help desk. There is the email, they can call them. If they have lawyers, the lawyers can keep on requesting. We also have our internal DCOS escalation emails and all. I have got it several times, I've got many times. But then if employers are trying to do it themselves, it will be a really hard time. So I know I cannot help with that, but I know many employers try to do it themselves. They cannot navigate all these questionnaires and all these things. It is difficult. So taking the help of some lawyers would be helpful. So 7 weeks. Banai Singh, do you have costs in care home without job? Sorry, we don't give costs. We don't provide recruitment. Uh, Samir Irfan, can you explain about student can bring dependent? Student bringing dependents. Yeah, I think students who have started their course of study from the January batch onwards, January this year, they cannot sponsor dependents unless they are doing either a PhD course or, yeah, so something related to PhD. That's what briefly I can explain. I think there are other videos that I've made around the July 17 change last year when the student visa rules were declared. A dependent's not allowed. But yeah, if you're not doing a PhD or a thesis related studies, then you cannot sponsor a dependent. That summary answer is UKVI General eligible for this UKVI General. Yes, UKVI General is fine. You can usually give UKVI General rather than, I know there are UKVI General and UKVI Academic. Give just UKVI General. I have used many certificates which are UKVI General for skilled worker applications. Yeah, it should be in all four components. UKVI General is in all four components. I remember it's speaking, listening, reading, writing, all four. Okay, next question. Okay, Nava Manoj Samir is taking. Administrative review is another area which is mess like decauses. More than 12 months is the current waiting period. For admin reviews, you asking, I think Nava, you asked about admin reviews more than 12 months. Some of the admin reviews are even going up to 1.5 years to 2 years that I'm aware of. Yeah, so hello. Should we need to carry physical copies of the uploaded supporting documents for the biometric appointment, or just passport and BNP originals are enough? No, you don't need to carry something that is already uploaded on the portal. When you go for the VFS or TLS, whichever appointment, wherever you're going, they may ask you, do you want to scan things? You can tell them, I've already uploaded everything. It's a part of the service, I think most of them give. You just carry your passport, appointment confirmation, and if you're going outside UK for the appointment, you also need the checklist. I think you sign it in front of them. So VFS is also doing away with signing once you upload it. I think in India last week we filed some skilled worker and they said you don't need to sign the checklist, but do carry the checklist also. I think that is a part of the process. So checklist, appointment confirmation, and passport are costs allocated now for care worker visas in care home. Yeah, costs are allocated. Watch this live. I've talked several times. Whatever issues are coming with costs, I've explained everything on this live. There are at least 10 questions that came on D costs for senior care workers. Yes, they are allocated. They are assigned. They are allocated to care homes for care workers, but there is a lot of checking and scrutiny going on. So, are you processing for this visa? Yes, we do all types of UK immigration applications. So, if you want to contact our office, you can go on the YouTube channel and there should be a website. You can fill up the contact form over there. Yeah, so yeah, someone from office will get back to you. I usually don't monitor that, but then yeah, you can send the inquiry. Mohammed again, please talk about the COVID overstay till 31st August still and their exemption. I left before the grace period, but our home office bothered about it and are they asking about the dates of past travel specifically? You should try to maintain. That's my answer about COVID. They whatever exemptions our CIH team was giving those emails, those are in your favor. That is perfectly fine. That is not treated as an overstay. Home office has confirmed that that will be in your favor. COVID has not been placed in the immigration rules. It's still in the guidance. It's outside. But Home Office has been taking a lighter view on it. But please maintain whatever your list of absences and all, give them clearly, explain in the covering letter or anything that you may have, whatever periods if you overstayed and you had that CIH leave and the COVID exemption leave that they were giving, explain it to them. They will be interested. The more information you give them, the better. If you've not overstayed, if you followed all the rules, what they told you should be fine. That's what my answer is. But try to give them the exact dates as much as you remember. Look at the stamps, e-tickets, whatever you can find. Can I switch to my unused PSW from skilled worker visa? Unused PSW? No, you cannot. Once you are switched from graduate route to skilled worker, that's the end of your graduate route. You don't get it back. So, yeah, I answered that, Akhil. Next question on the channel. Don't know. I have 1 year, 1 month left to finish my PSW. Yeah, so the next question is about new entrant visa. How long can you the I only used 1 year of the PSW. 1 year of the PSW. So I think it is from the grant or is it from the use? Let me check. New entrant. I'm trying to find the answer how long you can apply for the new entrant visa if you already have used up some of your PSW. I'm looking at the immigration rules. Just a minute. The applicant is completed, is no more than 3 months. Okay, that permission. Combined skilled worker, graduate route, and tier 2 would be more than 3 years and 4 years in total with the permission, whether or not the permission is for a continuous period. Okay, so the question is you got the PSW visa for 2 years, however, you used only 1 year and 1 month. Now you want to switch to the new entrant category of skilled worker visa. If I apply now, so the total stay, this is how the immigration rules say. You can only get the new entrant period. This is what is counted towards the new entrant period. Skilled worker, graduate route, tier 2 migrant. So if you already had permission, so the using is not considered. If you have been given 2 years of permission and now you're applying, you lost those 2 years. Total you can get is 4, so remaining 2. So my answer to your question summarily is I just want to have a new finish. If I apply now, eligible for you are eligible for 2 year of new entrant visa if you apply now because you've already granted 2 years of PSW, whether or not you have used it because it says combined permission. It doesn't say whether you used or not. So the answer to your question is you can get 2 years of new entrant visa if you have not used up any of the skilled worker or tier 2 migrant category. I am calculating only graduate route 2 years that you have used up. So next question, got job company before switching to PSW. So Akhil, I got a job in an IT company before switching to PSW. Can you tell me the order of events? From student, you became a PSW or you became a skilled worker? So just clarify that. I'm not getting it because in the first line you said, can I switch my unused PSW from skilled worker visa? You were a student, you got a job before switch. Okay, so instead of getting PSW, this is how I understand this. You directly went from student to skilled worker category. You did not get into the PSW graduate route. No, that is lost. You never used it. That is lost. Your opportunity is gone. Only from student you can switch to graduate route. You cannot switch from skilled worker to graduate route. So sorry about that. Uh, Okay, out of four members family, father, mother, two kids. If we are applying for a visa for one parent and two kids, one parent, two kids together, should the second parent also be present at the biometric? It depends on the form. You have to state who will be with the children, who will be the responsible adult. You have to put that, and that responsible adult should be there. That is how with children it works. So I know there are mom, dad are there, and let's say the dad wants to go with the two kids who are under 18. On the form, you should mention who will be responsible adult on the form of the kids, who will be the responsible adult, who will be accompanying the child, whoever that is. You can put mother's name, father's name, whatever, whoever is going to accompany, and one should be fine. It always asks one responsible adult, so I think from practice one adult should be fine. Okay, next question. I'm in Pakistan, my husband cheated on me, left me alone in Pakistan, went to UK, got married there. Guide me why I should complain against him. Okay, so this is a common transnational abandonment. It's kind of a domestic abuse. We have been fighting with Home Office on this. We have been raising this for about last 2 3 years now. Finally, some rules are in progress. They've already published the rules. They will be coming into play. So your case is your husband cheated on you, he left you back in Pakistan, and then he came back and he may have got married or whatever. But yeah, he has, that is a part of domestic abuse that is also treated. Home Office has accepted there is some visa category application. They have just released it as I'm talking, maybe this week or so it has been released. The draft rules are there. The best way to go forward would be for you look for the charities. One of the charity that I remember is Rights of Women org. I think that's what if you Google search for it. Yeah, it is the Rights of Women .org.uk. That's a charity. They deal with all these types of applications. I know that. I have my colleagues, so other lawyers are there who we talk to regularly. So it's a charity. Maybe speak to them and tell them your case about this transnational abandonment. They may be able to help you and guide you as to what you can do about your case. So how long how long get the visa cancel? So spouse visa will relationship breakdown. So there's a question on my video for relationship breakdown reporting to UKVI. I've made that one. So the question you asked is how long get the visa cancel? So as soon as Home Office gets to it, sometimes the visa is cancelled. So this is a question on a spouse visa holder. If the sponsor reports to Home Office relationship has broken down, then Home Office will actively cancel the visa. So usually sometimes it happens in 1 or 2 months, sometimes it may not happen for 6 months also. But recently I have seen they have done, I remember one case, in about 2 months or so, they usually try to pick it up because it's a digital system now and they are picking up, they may cancel it within 1 or 2 months also of the reporting from the sponsor for relationship breakdown. Mohammed Hassan, sir, while updating employer on skilled worker visa, do I need to pay old health surcharge? Old health surcharge 624. Do, while updating employer on skilled worker visa. Yeah, that is there is nothing called as updating employer. That is called as change of employment. I know people always use this term updating employer. You don't update employers. You make a new application. Sorry about that, Mohammed Hassan. So whenever you change employers, you make a new application for change of employment. That's what you do, and you have to pay the new IHS, not the old one, whatever the rate is. If you're paying it now, it will be 624 per year. If you do it after 12 o'clock tonight, then it would be 1035 per year of visa. New surcharge you have to always pay. And the previous one, whatever that was, proportionately that will be refunded. So next question, CP UK. I'm a skilled worker visa now. Applied for a skilled worker visa dependent as my current job is not good. Okay, and I'm not eligible to work till skilled worker dependent visa becomes for a different employer. Let me think. So you are asking. So you are on a skilled worker. You filed an application for switching to becoming a dependent. Am I not eligible to work till getting skilled worker? So my skilled worker rights only allow me to work. If you are already working with your skilled worker employer, the main employer that you had the skilled worker with, then you can work 20 hours as per the rules of the skilled worker. But those are the only, you are still under the skilled worker compliances. So 20 hours extra, either in shortage occupation or in the same job code. That's what you can do. You can work as per, so you should follow the compliances of the previous skilled worker visa till the time your new dependent visa is approved. Okay, Mohammed, thank you. Appreciate all your answers. Very clear. Thank you. Okay, next question on I got self-trader business. Would it be okay for me to invite my brother on sponsor visa also in terms of applying with my employees overseas? Same application apply workers then. Thank you. Okay, the question is about employing relatives on sponsor license. So if you you have a sole trader business, I think you should be able to justify why you need that person, why you need the relative, if they do qualify on the credentials, merits, experience, whatever that is. Also, with employee, if it's a relative you are trying to hire, definitely you should also try to do the resident labor market test and try to justify to home office why you are hiring a relative. One of the reasons is you were not able to find anyone in the resident labor market. So yes, it is possible. There are some restrictions on the relative cannot assign the cause and all of that. You may have to use lawyers and all to get to be added as the key contact or legal representatives on the license. They may have to get their own level 1 user access and apply for the certificate and assign the certificate to the relative. So relatives cannot assign certificates to relatives. That's a restriction. Okay, Akhil, is the IHS refund credited to the employer or the employee? It's credited to the same credit card, debit card, whatever was used to pay. That's how it goes by default, unless you contact them and you try to sort it out with them. It goes to the same card which it was paid with. I have 5 years of skilled worker visa and which 3 hours remaining. If I change job or go back to my home country, can I get the IHS refund? If you change job and pay new IHS, you will get a refund. If you just go back to your home country, you don't get a refund. That is what immigration rules are. So if you are changing job from one employer to another, you will pay a new IHS. So the way the logic works is, if you change employer, pay a new IHS, the old IHS will be paid back, repaid back to you, refunded to you proportionately to the same card, unless you contact them and try to sort it out, give them authority, give a new card, whatever the problem is. Okay, there is an NHS refund scheme. If you Google search, you will get it. If you leave the UK, you don't get IHS refund. With my employer, but I have a contract with them to pay 25% of it if I leave my job before completing 3 years. Yeah, all those side contracts that you made, you need to speak to contract lawyers and all of that. I cannot advise you on those matters. So only the IHS part I can tell you, you and your employer have to sort it out with whatever the refund situation is. I can only tell you what will happen as per the immigration rules. Mohammed Hassan, one more question. If we change employer on skilled worker visa for IHS refund, can we request EQI transfer refund on different account than the original account that was used first? Yes, Google search for IHS refunds. It gives you some helpline numbers. There are some emails and all. It's quite an exercise you'll have to do. Write to them, give them some authority, send the new details, tell them that someone else's card was used or you lost the card, and then give your new card details. Basically, they will, legally speaking, they will refund it to the applicant. They understand because the applicant's name is connected to the IHS reference number. So when they will ask you the IHS reference number and all of that, once you give them, they will find that the reference is connected to your name. So if it is Muhammad Hassan, then it is connected to Muhammad Hassan 1234 IHS ref. That is it. So they will try to pay it to that Muhammad Hassan. If they get the card details, bank details, or whatever, they will try to work with you on that. But you will have to actively maybe follow up with them and give them that. to pay ISC when they assign costs, or they do pay it after receiving entry clearance. They pay it when they assign the costs. Immigration skills charge is paid along with the 239 cost fees. So when they assign it to you, they put your passport details, your address, everything. And when they assign it to Muhammad Hussain, so if they're assigning it to you, at that point, I just assigned one today, so I remember it very well. So yeah, the 239 comes, below that the ISC also comes, it totals up, and the total fees should be paid when you are assigning the cost to the migrant. Here is a copy of the latest approval letter for okay, do you have a parent visa granted? I think, Philip, I have answered several of your questions on the channel, but still do have a case where parent visa was granted under 5-year route. Question is, parent visa, was it ever granted under 5-year route? With my experience, yes, I have done several cases where parent visa was granted under 5-year route. If yes, can you share a copy of the approval letter? No, sorry, I cannot share a copy of the approval letter. But then, yeah, for your case, speak to an immigration lawyer, get advice, and see if you are eligible for a 10 or a 5-year route. Do it with someone who has experience doing these parent visas. I have done many of them, so I know these rules left, right, and center. I have argued with Home Office on many points where they have granted my client on 10-year route, and I was fighting on 5-year route. Some of them I got through, some of them because there is no appeal. Once they give you 10-year or 5-year, there are no appeal rights for once a grant of leave has been given. So, but still on the side, raising it through Home Office seniors and all, I fought on some of them, got them on the 5-year route, but some others, yeah, they didn't budge and they explained it in detail. So now I understand the rules very well. But briefly speaking, they give you on the 5-year route on the parent visa if both the parents of the child are not together. If both the child parents are in a relationship anyway, whether living together, not living together, but if they are together, like they are together, I know that you may be pretending. I know sometimes people try to pretend and they say we are not together and all of that. It doesn't work out very well because affidavits and statements need to be given by the other partner and all of that. So if the facts of the case are both the partners are together, then 5-year route is unlikely for a parent visa. If both the partners are separated, then 5-year route is possible provided other things are met. One of the main things is the individual has current valid leave. So I've done cases where husband and wife, they have a child, they decided to divorce, okay, and obviously the spouse visa will be terminated. So before that terminates, we have switched the parent onto the parent visa, and we got a statement from the wife. So this just an example of a husband wife. Husband was a migrant from other country, wife was a British citizen, child born, child was British. I've done 2 children, one child, many of them. So just one example that I remember. And the British partner, she gave a letter saying, yes, the father is involved in the child's life. We gave all the evidences of whatever attending. One of the daughter was also older, college school, whatever letters from the schools and all, and proved that the father was involved in the life of the child. That was one aspect of it. Second aspect is the other parent should be supportive. It helps the case. Getting an affidavit, we have the affidavit format on our website. It is there. If you look for parent visa, you can download. Parents are together, parents are not together. Two affidavits formats are there. You can use that. We have used them that affidavit format many times successfully. So yeah, that is all about parent visas. Yeah, so but speak to an immigration lawyer if you are considering 5-year, 10-year. If you don't care 5 or 10, then just apply. But if you are really looking at I want 5-year only, then assess all the points properly and get it done. Okay. Oh my. Let's see. Okay. Next question, Mohammed Hassan. Thank you. Very helpful answer. Specifically, you told that legally UKBI are bound to pay a refund to the applicant. Yes, legally speaking, they are bound to pay any fees because you have to think it logically speaking. If I am the applicant, my name is Sachin, I put my name on the form, I pay the fees. It is technically speaking, by default, it is my fees. I may have used anyone's cards. I may have used my wife's card, my friend's card, or employer's card. But when my name is on the form, that money is linked to me. I have paid the money. So somehow they should be obliged to you because anyone else has given you authority to use their card. So the IHS refund has to go to the employee, to the applicant. Okay. Monipi sir, any update on shortage occupation list? When is it going to be published? Current shortage occupation list is still live. No changes to it yet. They are reviewing and they will scrap it and come up with some new list. There is some new name. It will come around April. But currently, whatever the shortage occupation list is, that's the same one we are using. That's the same one we are getting approvals for. Yeah. So whatever the current shortage occupation, that's still live. The new one will come around April sometime. We are working on it. I think so around April. So all the questions I think are done. Please, when we are hosting the next live stream. Okay, everyone has joined the live. I have answered all the questions and I have to go and eat now. It was a long live, 70 minutes. Thank you very much everyone for joining the live. I'll go live maybe sometime next this week. It provides usually in the evenings after 4 sometime if I finish work on time. So today I finished by 6. Yeah. Yeah, thank you very much. I usually don't work after 6. Yeah, so I have young kids. Okay, thank you very much.